Let's then turn to our first talking point tonight. Has the time come in to change the law to ensure a juvenile doesn't get away with lighter sentencing in rape cases? Joining me now in the studios, Bharti Ali Haq. She's co-founder Haq Center for Child Rights. I'm also joined by Neena Nayak, member of the National Commission for Protection of Child Rights. Also C. Aryama Sundaram, senior Supreme Court lawyer, and Amod Khan, former IPS officer and General Secretary of Prayas, an NGO that works among children. Appreciate all of you joining us. Let me come to you, Ms. Haq, for starters. Should a 17-year-old get away in a gruesome gang rape case by simply virtue of being a juvenile? Surely that is not what this juvenile justice law was designed to achieve. He is only 5 months under the age of 18, but will probably get away with a much lighter sentence.
Well, I would like to bring to everyone's notice the fact that once a person is convicted, whether it's for 2 months or 2 years or 20 years, the fact is that your record says you are convicted.
But look at the nature of the crime, ma'am, that he's committed. He is the one who actually is allegedly the person who was responsible for bringing that girl from the street to the bus. He submitted her apparently to the most brutal assaults. Should he be let off simply because he was 6 months under the age of 18?
There is no doubt that the crime committed is very, very heinous.
Yes.
And needs to be condemned. But at the same time, there is enough statistical evidence to suggest that the stricter the punishment, the less impact it has on people.
The reason I'm asking yes, go ahead, ma'am, sorry.
The whole objective of the law is to bring a reform in people who are under 18, give them that chance to work on them. And there is enough evidence also to suggest that when juveniles commit such crimes, it's always in group.
And you treat a 17-and-a-half-year-old as a juvenile? Do you believe that he is someone who did not know what he was doing?
There is an age limit set out at 18, and there has to be some age limit set out. Where today it's 18. If it was not 18, it would have been something else. But then, if it had been 16, for a 15-and-a-half-year-old, the same question would have arisen. But you have to set an age limit, and this came about after serious recommendations from the Committee on the Rights of the Child, as part of the UN Convention that India ratified in 1992.
I'm going to come in a moment to look at this whole debate between reformation of a child, someone who commits such an inhuman crime and a dastardly crime as he did with this gang rape. But let me get an NCPRI perspective. Neena Nayak, where does the NCPRI stand? Do you believe that time has come to at least review the provisions? Number of juveniles arrested, ma'am, and accused in rape cases under Section 376 of the IPC went up from 858 in 2010 to 1231 in 2011. That's a 43.7% rise. Surely the child rights activists need to relook this entire definition of who is a juvenile?
Yes. I endorse what Bharati has to say. You know, it's for so many years we have, fought to get some kind of justice for children. And if you look at this case of this child, I feel that we as society, larger society, has really failed him. From the age of 13, this child has been on the street. Even if I don't look at specifics, even if you don't look at this particular case, tell me what kind of support are we giving children who are in need of care and protection. This child comes from a very, very difficult background, and there are
ma'am, but how is he different? Sorry to interrupt. How is he different to the 19 and 20-year-olds who are also involved in the gang rape? Simply because he's 6 months under the age of 18? Am I to understand that he was an unthinking adult?
See, we don't have it's not an unthinking. I mean, this age, when you talk about his age of 17, still immature. Please understand that he hasn't got the kind of family life that you and I have enjoyed. He doesn't have those kind of facilities. And who was his mentor? His mentor was Ram Singh. He was with him all the time. For 1.5 years, he's been with this fellow, groomed by him. So, young, impressionable mind has done this. I completely condemn the act. The boy was. And he was doing his job. He was employed by the bus company to beckon people. He was doing his job. He got in, and then there was this kind of a mob mentality. Definitely, you should not be doing. He
ma'am, you're condemning. You're condemning the act, but you're saying that he was immature. Aryama Sundaram, why are you smiling? Yes, do you believe, as a senior Supreme Court lawyer, that the time has come to review the law? Yes, Mr.
I am shocked.
Yes.
Rajdeep, I find this highly paradoxical.
Yes.
You know, when we talk about, the background of a person, if he's 18, if he's 17 years, 364 days, then his background will exonerate him from what has just been said. If he's 1 day older, he can be punished. No, there's something very wrong here. Look at the basic paradox. A heinous terrible crime is committed by somebody who's 17 years, 364 days.
Yes.
It's a one yardstick. One day later, it's totally different. I fully agree that the law as it stands, there is a cut-off age given, and I think one of the panelists just said, well, what if the age was 18 and 16 and not 18? Wouldn't the same question be asked? And the fact is, the same question will be asked. And the reason is this: there is something very arbitrary about these things about fixation of an age.
Yes.
A person who comes from a terrible background, a very repressed background, could equally have a justification. If a person at 17 and a half has a justification, a person at 18 and a half could have the same justification.
Yes.
I think the basic test ought to be, and many countries in the world have that test, is that does the person who is committing the act,
Yes.
is he aware of the nature of his act, the grievousness of what he is doing, and is he mature enough to understand what he has been doing? That is really the test, not to put an arbitrary age limit. Let us understand one thing.
Yes.
We must draw a distinction between very grievous crimes and perhaps crimes of a much lesser magnitude, which one can try to put an age and then say, all right, beyond this age you are guilty, below this age you will be tried differently. But when it's a grievous, heinous crime,
yes,
I think the test is the same test as for anybody. Are you aware of the magnitude, the nature of the action you're doing? Are you mature enough to know what you're doing?
So
the effect of what you're doing,
I think
the consequences of what you're doing.
You're making
and I feel that should be the test.
You're making an important
not
point.
An arbitrary age limit.
Let me take that to the child rights activist before I come to the police officer. Respond to that, Ms. Ak, because in UK, minors can be tried in an adult court in exceptional circumstances, in the rarest of rare cases, if the nature of the crime is of an exceptional variety. Why look at age? Why not look at the nature of the crime?
True, but in UK, it doesn't mean that sexual offences by youth offenders have reduced.
I'm not saying
reduced.
Surely don't you believe that it could have a salutary effect, it could have a deterrent effect?
Let me tell you something, Rajdeep. If you look at the Juvenile Justice Act carefully,
yes,
it has a range of orders that can be made for juveniles, and ranging from advice admonition to a maximum of 3 years.
Maximum of 3 years. This boy could be out of prison in 3 years, out of a juvenile justice home in 3 years. He could be back on the same streets.
So do we want an 18 to 21-year-old to be inside for the rest of his life?
If the others involved in the same crime have got life imprisonment or get death penalty, he gets 3 years and is back on the street.
Without being given an opportunity to change at all, you give that opportunity only up to an age, and beyond that age you don't get that opportunity.
This question of reform, Amod Khan, because you work with a children's home, your NGO works among children, do you really believe that this boy can reform by being given, let's say, maximum of 3 years, given the nature of the crime? Aryama Sundaram is making the point, forget age, look at the nature of the crime and the knowledge, whether the child or the juvenile had the knowledge of what he was doing. Shouldn't that be the test case?
If you permit me, I'll give the complete picture. Do I?
Yes.
See, on the one hand, my ex-police colleagues have charge-sheeted the other accused persons.
Yes.
On the other side, let me inform you that in this particular case, Prayas runs the Rape Crisis Intervention Center, which is dealing with the case of that, the girl, the 23-year-old girl.
Yes.
And that case is being dealt with by Prayas, so I understand fully well what is behind that case, what happened to this tragic situation.
Yes.
On the other side, Prayas is running the juvenile home, where nearly 25% of the juveniles,
yes,
they happen to be involved in serious crimes like rape and murder. They are still with us. And let me inform you that I have an opportunity to talk to them every now and then. Now the issue is that Juvenile Justice Act has a reason behind it. Juvenile justice system has a reason behind it. It is believed that the children below a particular age, when they don't have that kind of maturity, whatever age we decide for the child, and 18 is the age for the child in India, if they are sent to normal prisons, if they are sent to a kind of jail, their life would be completely spoiled. My experience is, let me tell you, personal experience, I interact with these children every now and then,
yes,
and I told you that there is a program going on with Delhi police under which 100 juveniles we are interacting these days. 25% of them happen to be involved in these kind of crimes. And they are reforming. In fact, they are having much better results are coming because they happen to be in a home, because they are being dealt with by the counselors and different kind of people. So the Juvenile Justice System, Juvenile Justice Act has a very strong and powerful philosophy.
Are you saying it's working?
And that system must continue.
Are you saying that you have some reason to believe that a 17-and-a-half-year-old boy who committed this horrific crime can reform under the juvenile justice system?
We have live.
Not only that, I have reasons. I am fully convinced.
We have examples.
I am fully convinced. I am fully convinced because there are hundreds of children with whom I have dealt with. In Prayas itself, we have got these kinds of children, many of them. And because we are running a proper kind of home, juvenile home with us, the proper arrangements are made. We find them repentant, we find them reforming, we find they're changing.
Okay, you find them changing. Let me just take that to the child rights activist Neena Nayak. Do you believe that they will actually change? Do you believe that we are at the moment that the battle is between retribution and reform?
Yes, if you look at them compassionately, if you give them opportunities, if you really help them to go on in life, they repent, they reform. I've had an opportunity to deal with many of these children. They're affectionate, they're loving. They've just missed out a childhood. They've had brutal childhoods. I'm sure this child himself was a victim of a lot of abuse. Where was our system to protect him? I feel that I and General, we have failed this child so badly.
No,
I'm not talking about this particular
why not look at at least in exceptional circumstances what Aryama Sundaram is saying, that in exceptional circumstances the nature of the crime is such, do not look at the age. No, and if you look at the system through which you go in, if you don't keep a cut-off age, already, Arnab, you know that so many children, young boys were in Tihar jail. Which system looks at the age? The court says you have to have an age memo, you have to get... See where our children are landing up at 16, 15, they're sitting in Tihar jail. So I think a cut-off age is very important. 18 it is, and we should work within the system. Let's strengthen our protective mechanism. I get your point. I get your point. Aryama Sundaram, respond to what you heard, that here's a police officer and two child activists who are saying we need to strengthen the system of Juvenile Justice Act. We need to reform children. We don't need to punish them in the manner that we do adults. Your response?
Rashdeep, yes. The question of reformation is important for any criminal.
Yes.
In punishment, the jurisprudence for punishment is that it is deterrent, it is retributive, and it is reformative. Different systems promote one or the other. In India, we try to follow all three. The same way as you may say that a youngster of 17 and a half has a chance to be reformed, equally a first offender of 20 or 21 has a chance to be reformed. Equally, as a 17 and a half may come from circumstances which drove him to commit such an offense, a first offender of 21 or 22 may also come from similar circumstances. So while on the one hand reformation is always an important part of the punishment theory, retribution and deterrence are also important parts of it. Now the point I'm trying to make is, at the stage of punishment, when the judge metes out the punishment to be given for a given act, that is when the questions come in as to whether there is a sign of any repentance of the accused, whether the judge feels this is an accused who can reform or not. That is the stage it always comes into play. But we cannot say that because there is a chance of reformation, try him differently. Do not charge him with the murder that he should be charged. Do not charge him with the kind of punishment that he can be faced with. That is a totally different issue. At the stage of deciding the punishment, of course, consider all three. And all three are considered by the Indian But I refuse to accept that if a person knows the kind of action he's doing, a 17 and 3/4-year-old boy knows what he's doing, is aware of it, is mature enough to know what he's doing, and is dangerous to society, I do not feel that magic figure of 3 months should make a huge difference. On the other hand, if you're convinced that he really was not mature enough to know, then whether he was 17 and 3/4 or 15, there's no difference.
No, the point is...
That is a judge's job. That is the court's job. Madam, it is the job of organizations such as you to be able to test the accused, to be able to test the accused,
who cannot even sign the Vakalatnama to get a lawyer for himself.
Let us not go away from that.
Mr. Sundaram, you made your point. Ms. Haq, the point is there are three principles to the law. There's deterrence,
right,
there's retribution, and there's reformation. You're focusing only on the third. What about the first two?
No, we're focusing on all. That's why I said there is a range.
Principally focusing on reformation.
I just have one.
As what Ariyama Sundaram is saying, at the stage of punishment. Why should he be treated differently at the stage of punishment?
Okay, then I have a question to Mr. Sundaram, which is that a person below 18 cannot even sign a wakalatnama to have a lawyer for himself. You need your parent or guardian to sign your own wakalatnama. How can you treat that same person in the system which is meant for adults where you can?
Why not allow the judge to have that discretion? There is a judge there. Let the judge decide whether he believes that this individual will reform, whether he believes that this is a deterrent, whether he believes that this is effective retribution.
But how do you decide 18 is the age when you can legally enter into a contract?
Yes.
And below 18 you cannot enter into a contract, but then you at the same time you want 18 to be reduced to 16. So are we then going to allow a 16-year-old to be able to dispose of property?
We are saying even if the age remains 18, why not change the system? I think that's the point that Mr. Sundaram is making. What's your question
and
though
the
to
system, my question is that a person who doesn't have a right to get legal representation for himself as easily as an adult, how can you put him into the same adult system? One.
Yes.
And the second question is, the comment is that there is provision in the law under section 18 of JJ Act which says that if there is a juvenile who is a threat to himself or to others, then there is something called a place of safety where this child can be kept. Doesn't have to be kept with other children in special homes.
Respond to what you've heard, Ariyama Sundaram.
My only response can be is that it's a very dangerous precedent if we start taking an arbitrary age in criminal actions.
Yes.
Yes, it's a fact that so far as contract is concerned,
yes,
civil matters are concerned, we have an age.
Yes.
But look at it this way.
Yes.
Equally,
yes,
a person who's of insane, of unsound mind,
yes,
cannot equally contract.
Yes.
A person who's under coercion equally cannot contract.
Yes.
Same way that a minor equally cannot contract.
Yes.
The point I'm making is,
yes,
and so we treat them differently.
Before you try, one moment, let me finish, madam.
Yes.
It is one of the main ingredients to, before you determine somebody is guilty, to know whether they were in faculty of their senses, whether of sound mind or equally, whether they were mature enough, old enough to know what they were doing, before you decide to even find them guilty. Now that will be there at two stages. One,
right,
organizations such as these can always go into as to whether the child had the maturity, whether in all ways the child was really a man who knew very well what he was doing, who had the full maturity or not.
So you're saying
an important thing to be considered before finding him guilty,
okay,
or equally before punishing him.
Okay, there is another
arbitrary age.
Okay, you're saying remove this arbitrary age limit. Do not just go by what you're calling an arbitrary age limit. There's another question though, Amod Khan, which is the question of the state of juvenile justice homes in this country. We are saying that they will be reformed. You say in Prayas, which has been one of the most successful experiments, you've been able to reform a lot of young juvenile criminals who've come to you. But the quality of juvenile justice homes across India are not the best. And is 3 years enough? People will ask, is 3 years enough to reform a kid or who's committed such an act? I come back to it. The fear factor will be there. He's back 3 years later on the road. God forbid what happens if he's not reformed.
No,
I still feel that the homes have to be different.
Ms. Naik, let Mr. Kant respond.
Can I clarify the position?
Yes, go ahead.
Can I clarify the position?
Yes.
See, I still feel that the juvenile homes, yes, maybe there are many homes which are not being run properly, but still a home is a home. The home is not a jail. And for a child, the child has to remain in a juvenile home.
3 years?
So that those preconditions...
Is 3 years enough? Mr. Kant, sorry to interrupt. Is 3 years enough given the fact that he spent 17 years maybe on the street?
I think 3 years is enough, but if somebody wants to extend the law, extend the period, I have nothing to say about it. Let them examine that part. But 3 years for the timing is good enough for the child to get some vocational training, for the child to get some counseling, some reformatory programs, some educational programs. But can I make one or two more small points?
Yes.
See, please understand, this particular child at the age of 13, he was separated from his family. He was definitely a child in the need of care and protection. Juvenile Justice Act has got two kinds of children. One is a juvenile who is in conflict with law. The other is a child in need of care and protection. This particular child is a typical profile of a child in need of care and protection. At 13, he came on the street. He had to leave his family, which was a very disturbed family. I believe that the father of this child was not mentally very sound. 6 brothers and sisters. He hasn't even met his younger brothers, I believe. And then he came to Delhi and some other places. He's on the street. He's a working child. He's a homeless child. So obviously he had all the kind of profiles and the conditions of a child who needed care and protection. It was not given to him. Can I just finish?
Yes.
Can I just finish?
Yes.
See, in that case, and otherwise also, all of us believe that every juvenile who has gone the wrong way also happens to be a child in the need of care and protection. Now to merge it all together and to convert a child in the need of care and protection in juvenile into an adult prisoner is not a correct thing. An age has got to be there.
Okay,
I think somebody is trying to say that there should not be an age at all. In that case, for no crime and for no law, there should be age.
But
the age, 18 years is a particular age. Listen to me. 18 years is a particular age. After that, the child becomes adult. He acquires right to vote. He acquires legal rights. He acquires many rights. And UNCRC has some reason behind. India has accepted it, and we have put the 18 as the age of the childhood.
So
there has to be dividing line.
I get your.
There has to be dividing line.
You believe there has to be a dividing line. Let me get final comments.
Decidedly.
Nina Nayak, do you believe though that yes, while we will concede that there is a need to have a dividing line, should there at least be some relook, some review? Given these statistics, surely these statistics, the nature of the crimes, simply cannot be wished away.
Let's look further at these statistics, Rajdeep. Let's see who these children are, what are their backgrounds, what protective environment we created for them. At the Commission, definitely we are re-looking at the Juvenile Justice Act, but we are looking to see this lean system should be strengthened. We should have enough services, because every child in conflict with the law basically is a child in need of care and protection. And I think we have to do something to support these children, to lead the kind of lives that you and I provide for our own children.
You know, Aryama Sundaram,
failures will definitely not happen.
Aryama Sundaram, are you convinced with what you've heard from Amod Nayak, Nina Nayak and Ms. Haq that maybe this child in extenuating circumstances needs to be treated differently, or should that decision be left to the judge and the people who are investigating the case?
I would like to believe that this child, as with any other first offender, we should try to reform them. I have no doubt about it, but I don't draw a distinction between a 17 and 3/4-year-old offender and an 18 years and 1 month offender, or a 24-year-old offender who comes from similar situation. In fact, that is why we have the system of law that we do, by which the judge goes into the question before deciding A, on the guilt, and B, on the punishment. And I do not believe that we should say that because you're below 18, you have a greater chance of being reformed, and if you're 18 years and 2 months, you have less chance of being reformed. We have to look at the enormity of the act, the gravity of the offense, the intent behind it, as to whether the person who was doing it knew what he was doing, was mature enough to do it, and was a vicious act, it was a vicious act or not.
Okay.
In which case, I don't think 3 months should make the difference, but it's the mental stage, what we call the mens rea, what we call the intention, which should make the difference.
Okay. Final word, Ms. Haq. There is a lot of anger and rage.
Sure.
You know, partly the reason why we are debating that, the reason why the focus has come is that 5 men today have been charge sheeted, a 6th will go to a juvenile court. There is anger. People want retribution first this time. Given that public anger, yes, court cases cannot be decided on the basis of public anger, but somewhere is there a need at least to review, given the statistics and the nature of the crimes that are being committed by juveniles?
Well, the JJ Act has been under review for some time for many other changes, except the one on reducing the age from 18, and which I feel very strongly, I feel it should not be lowered at this point of time or ever, for very clear reasons that there are enough studies to suggest that children up to the age of 18 are yet to develop mentally, physically, and therefore there has been an age that is that was set at 18, and we should not.
Maybe there are exceptional circumstances, the rarest of rare cases. If you have rarest of rare cases, death penalty, then rarest of rare cases, the Juvenile Justice Act needs to be reviewed.
And as far as the rarest of rare cases are concerned, there are adequate provisions in the existing law to deal with those rarest of rare cases by children who are under 18. And at the same time, let me remind you, juvenile crimes come to only 1.1% of total IPC crimes in the country. Only 1.1%.
Okay. Let's leave it at that for now. Obviously, this is a debate which will also be carried, hopefully, before the Justice Verma Commission, which is looking at reviewing the anti-rape laws and looking at the wider issues involved, but will also be part of our agenda for change. I appreciate all my panelists joining us here on our top talking point tonight.